because I think that this story is told best from the beginning through to the end. And this story has with it something that I've never seen in my 20 years, and that is from the moments after the accident, all the way through, audio, video, we can actually see a person as they're going through this unbelievable situation on through. You can hear on the 911 calls, which, by the way, the defense fought to get the full copies of those for you and brought those to you. They're 58 seconds apart. You can almost match them up and sync them if you could. And the reason it's so important is because you hear the truth and the panic and the trauma. You hear it and you can see it on the videos. The majority of the state's case is the 5.5 hour interrogation. You don't have all 5.5 hours, but you have a substantial portion of it. That's their case. From a kid who has gone through, Dr. Rowe describes as a criterion A traumatic experience. And inside of that, even inside of that, this panicked and shocked kid is telling you, I don't know what the fuck just happened. That's there. That's all there. And it is a kid who's trying to sort things out and figure things out. The state has several things in their opening that or their closing I want to talk about. They said that Skylar remembered how he was holding the weapon. And they said, this year, January 2016, in your notes, by the way, I want to say this is so important. Your memory and your notes, together with each one of these admitted exhibits, is going to go back into the jury room with you. I encourage you, I ask you, watch them, look at them, read them, ask for a computer, look at the photographs, turn that 911 tape up high. The state plays things two different ways. Every time Skylar can't remember something in a panicked and shocked incident, they think, well, he's lying. That's what he's doing. But when someone else can't remember something or forget something, and they're even further removed from this situation, they give them a pass and they say, well, that's just what happens. Officer Moore believes in his mind that Skylar had his hands in front. We know that didn't happen. But that's not because Officer Moore is not coming to court to tell, he's not coming here to lie to you. That's not why. It's because in his mind, that's what he thinks happened. Theodil believes she heard the gunshot, clearly heard the gunshot, even though she showed up much later and didn't hear the gunshot. And it wasn't an hour for the police to get there. But for her, it felt that way. She's not lying to you. Ben Bergmark cannot remember the interview he gave to the police. He can say, yeah, there it is, but I don't remember it. What I do remember is. That's important. The state says things like, they brought things in that we didn't talk about. They said, I didn't hear them yelling or pounding their feet. Well, there's a lot there in what you can hear. They said Hale was there when Foss was there on the drop-off point of October 16th? No, he wasn't. Hale said he had training and he left to go to training. He came back early to go to training. They make a big deal about Oakley being contacted during trial. Yes, Skylar didn't remember all the things until some time later. But Oakley came here, and Oakley told you the truth. He didn't come in here and lie to you. He remembered it, and he told it to you clearly, and not a single witness from the state came in and said, no, Foss was there. Foss came in, and Foss said that. They say, how would Foss know? Because every witness who spoke to Detective Jordan got information from Detective Jordan that Detective Jordan got during the interview. Detective Jordan even admitted that. Although he said it in such a way that said, well, I only gave him information after I got what I wanted. And then on direct, when I had him in here, he also said, well, yeah, I guess I gave him information and they gave me information. Or they gave it to me, I gave it to them, they gave it to me. It went back and forth, conversation. What does that mean? When you're the murder detective, right? You're the homicide guy. And you're giving information back and forth to a witness. You think that influences a witness? You think that influences their bias? You think it changes what they might remember or how they may come in and testify? Those are the things the state said that I wanted to respond to. When we talk about Danny and Skylar, we talk about how they met. How they met in California in October of 2012. How they fell in love. How Danny became part of Skylar's family. Skylar went to basic, and when Skylar came back for Christmas, he proposed and they were married. They graduates basic on March 7th. Gets married on the same day. March 8th, gets posted to JVLM. All those dates are important. They are married for less than 2 years. They move up here in April. The state says in their opening that they said, or their closing, everyone testified they were unhappy. No, they didn't. This was a happy couple, and they loved each other. We're going to start going through the jury instructions in a little bit because there's things we have to go through on there. Reasonable doubt comes from evidence or lack of evidence. The only evidence you are to consider is the properly admitted evidence from this judge. In the state's close, about half of the first part weren't even comments from Skylar. They were comments from the detectives. And the court has specifically told you those comments are not evidence. And so you've got a difficult task to do, to sort out what's in and what's out according to what the judge has told you. That's a tough thing to do. Those are tough gymnastics. But you have to. It's critical. The judge told you of the importance of the jury system. This jury system is everything. It's everything to a functioning country and democracy. It was hard won on the battlefield. It has been something that we have cherished in our tradition. And it only functions if you are here and you take your jobs as officers of the court as seriously as you can. And that means deciding things on evidence and properly admitted evidence. I will tell you that while we're talking about evidence, I want to talk to you about what's not there. and that is evidence of premeditation. There is no evidence of premeditation. They talked about time. I'm going to read the instruction regarding premeditation. And actually, you know what, before I do that, an overview. The court has given you 4 possibilities. Murder in the first degree, which is premeditated murder of another with intent to kill. Murder 2, which is the intentional killing of another. Manslaughter 1, which is reckless killing of another. And manslaughter 2, which is negligent homicide, negligent killing of another. I believe from all the evidence, from the first exhibits to the end, to Skylar's statements here and with the police, and this is hard for a defense attorney to say, I believe that the state has proven manslaughter in the second degree. I believe they have proven that his negligent operation of that weapon, his failure to be aware that it was loaded, that it is manslaughter. It is. Tell you what it's not. It's not premeditated first-degree murder. Premeditated means thought over beforehand. Thought over beforehand. Now the state says, well, you know, there's this timeline, it doesn't make sense. We'll go through all those facts. Okay? We'll go through all of those things. And they pick and choose what evidence they want to show you. Picked and chosen and edited to get the conclusion that they want. Plaintiff's 9, number 12. It's a picture of the kitchen. Do you think if you were going to premeditate the killing of another person, you would keep your window open in a busy apartment complex? No. They talk about, well, there's time enough to do these things, time between this and that. Time isn't premeditation. Premeditated means thought over beforehand. When a person, after any deliberation, and by the way, deliberation means long and careful consideration or discussion. You will have a great idea of what deliberation is because you're about to do it. You'll know what deliberation feels like. After any deliberation, they say, well, see, it could be any deliberation. Yes, but it must be deliberation. And deliberation is long and careful consideration or discussion. Forms an intent to take a human life. The killing may follow immediately after the formation of the settled purpose. What does settled purpose mean? It means that is the purpose upon which you have arrived. That is what you are going to do. The deliberation is the key portion. And it must involve more than a moment and point of time. It requires some time, however long or short, in which a design to kill is deliberately formed. Settled. To end or resolve. Design. Purpose, planning, or intention. Thought over beforehand. The state thinks that it's shown premeditation. What evidence of premeditation has it shown? I submit they've shown no evidence of premeditation. They wanted to show you evidence of jealousy, this issue with the alcohol or the roses or Jeremy Henry. But remember, what we're talking about is evidence. What evidence is there that Skylar Nemetz knew that Jeremy Henry had been hanging out with Danny? Let alone if he would do something horrible to Danny if he found that out. I mean, there's nothing in the record about that at all. But let's just focus on this. They bring up Jeremy Henry. Jeremy Henry says, well, you know what, when I was on the phone, she had me be quiet out of respect or because she didn't want him to hear me or whatever it was. But there's no evidence at all that Skylar knows about Jeremy while he's gone. None. They show this picture of a gun. They say one gun is on top of another. I don't see it. As evidence that somebody would have known. I don't see one gun on top of another in this picture. And you get to look at each photograph for as long as you want to, as well as you want to. And don't forget, I think it is Plaintiff's 54. I think it's Plaintiff's 54. I'll find it for you. You'll have it. These might be a little out of order. Because there's a CD. Not of the prints, but of the actual digital photographs. Look at it. Something's out of order, something's out of order. I don't see it. It doesn't mean you won't. But remember, evidence of premeditation. Where's the evidence of the planning? Where's the evidence of any of that? There's the next thing, intent. The person acts with intent or intentionally when acting with the objective purpose to accomplish a result that constitutes a crime. Skylar did not mean to harm his wife. The intent that they must prove is that Skylar meant to kill Danny. Now, the premeditation and the intent go together in first-degree murder. But let's look at what did happen. There's a gunshot, and Ben Bergmark comes to the door, and he doesn't hear anything for a second, and he wasn't planning on doing anything else until he starts hearing screaming, wailing. If you plan on killing somebody, are you then going to leave your window open and a sunny afternoon on a beautiful fall day in a busy apartment complex and shoot someone with a really loud AR-15 rifle? I don't think so. Doesn't sound like premeditation to me. It sounds like an accident. That's what it sounds like to me. And not intentional. And if you intended, and remember, murder 1 has premeditation. Murder 2 has intent without premeditation. Those are two distinct legal concepts. If you're acting intentionally with the objective to kill someone, you can do that, by the way, without premeditating it. But if you're acting with that intent to kill someone, is that what you do? Is that how you'd conduct that? In a place packed full of neighbors? And then, remember, it's not the gunshot. It's not the gunshot that gets anyone to call 911. It's a panicked, freaked out 20-year-old kid who's screaming and stomping and going, oh my God, Danny, no. That's what gets Ben Bergmark to come over and knock on the door. Hey, what's going on in there? And what do you see when he opens the door? What do you see? He said he was white as a ghost. White as a ghost. Why is that important? Because you can't fake the traumatic reaction, the fight or flight response, where your blood goes into your extremities and then your heart starts pounding and your body is ready to run or fight or faint and go into a fetal position. Those are the reactions. Dr. Thomas Rowe, can you fake that? Well, I suppose if you had some control over your rhythm and your heart and your, and he gave this explanation. The answer is no. You can't fake that. That's real. And so is the reaction of Skylar Nemetz and the back of that police car when he's handcuffed and he's stunned, and then you see the animation as these, you can literally see thoughts running through his mind. Literally see what's happening to him. And that's why it's so important to watch those. I didn't cut it up and play it for you because I realized that the blunted affect, after listening to Dr. Rowe, was just as important as the, I think, let me use the term he used. He's a doctor, I want to get this right. Getting to his report. Give me a second. The blunted affect was as important as the expansive emotional affect. Dr. Rowe testified. Trauma. A traumatic event is an experience that is perceived as a threat to one's safety, stability of one's world, followed by physical, emotional, and psychological distress. Trauma is the subjective experience of extreme stress that overwhelms one's ability to cope. Risk factors and determinants of severity of trauma include, but are not limited to, events which are human-caused. Goes on. Here are the risk factors for criteria A. Traumatic events. Directly experience, and by the way, one of them has to be present for them to find criteria A. And here we go. Directly experiencing the traumatic event, witnessing in person the events as it occurs to others, learning that the traumatic event occurred to a close family member or loved one. The events must have been violent or accidental. We have all those. We have all of them. On the state's cross-examination, Dr. Rowe testified that you would expect to see a greater reaction from someone if the results were unintentional. The state elicited that from Dr. Rowe. Because if you plan to kill someone, and you do, you're not shouting, "Oh my God, Danny, no!" with your window open, stomping around, alerting your neighbors, answering the doors to your neighbors, babbling incoherently, and look at how each one of them described him. Everyone described him, the closer to the event, crying, panicked, screaming, wailing, yelling, in the fetal position, going limp, white, face white as a ghost, nonsensical, repetitive speech. He was in shock. That's how everybody described him. But a couple witnesses said, well, I didn't see actual tears. Dr. Rowe came and talked to you, and he said, sometimes people come to me for the primary reason that they can't produce tears. But I saw plenty of tears in this courtroom. I was sitting right next to them. I was here, and you were here. This is an unbelievable event for a 20-year-old, for any of us, but for a 20-year-old. You're called everything imaginable. State says that you murdered your wife, and you did not. How does one defend oneself? Mostly people just want to crawl into a ball, fade away. Sometimes people's brains shut down and they don't remember things. It's true, you didn't remember Oakley for a while. Oh, and by the way, that whole thing with Greer and Skylar on the stand about the declaration of probable cause that didn't even state Foss's name and didn't even state these things happened near the truck. I don't know if that was just some show for cross-examination, but the truth is, that document never mentioned Foss. Never said anything at all about the events of Foss's purported talking to Skylar about alcohol happening at the truck. Didn't. When it became known, it became conveyed, and it was relayed, Skylar says, yeah, okay, I think Oakley was there. And Oakley was called, and Oakley came in and said, I was there. Oakley, in the Army, came in here and testified, I didn't see Foss there. And he would remember Foss. Because I promise you, if you broke somebody's teeth out, you'd remember the next time you saw him. You'd be looking for him. If you backed into somebody's car in a parking lot, your neighbor, you'd remember seeing him next time. Foss wasn't there. They made a big deal about bottles. And they said, if drinking was such a big deal in the military, why would a 20-year-old be worried about it? Because it's illegal, and you get a ticket for it. The NCOs don't buy it for the junior enlisted men. The other enlisted men buy it for them. Drinking is condoned. Getting caught with alcohol is a criminal offense, and it's punishable, and it gets punished all the time. You lose a driver's license, all kinds of bad things happen to you. Yes, he didn't get rid of things that were not in his sight, but he did the things that were in his sight. And he dropped the gun, and he picked it up, and he threw it in the closet. The blood evidence tells us some things, not everything. I don't know the clotting properties of a middle finger. I don't know how all that can be reconstructed. I know this. I know that the DNA evidence is only good as the swab. We're going to talk about forensic evidence in a minute. Back to the response of Skylar. They talked about, Dr. Rowe talked about a brain overwhelmed. He talked about a person showing expansive affect and blunted affect. He basically described from a textbook. Think about that. A textbook. The reactions of Skylar. Now, they want you to think that when their experts testify that this is just honest to God truth, couldn't be any different, but somehow, I bring Dr. Rowe in or Dr. Sweeney and they're jukeboxes. I think that's absolutely demeaning. I don't think that anyone came in here with the intent or the purpose to come in and play you a song. If you think that Dr. Rowe somehow invented the DSM-5 statistical manual, diagnostic statistical manual, wow, we really are good as a defense if we were able to come up with a doctor who could invent that manual. Instead, the truth is the DSM's been around for 60 years. When Dr. Rowe came in and talked about trauma, it has 60 plus years of research behind it. And when he talked about criteria A events, those weren't written for Skylar Nemetz. Those are actually criteria A events. And when he talked about expansive emotional affect, blunted, disconnected emotional affect, avoidance, the inability of the brain to deal with that level of trauma because the response that's going on. Think about the response that's happening. You're going through this traumatic experience and your brain is radically altered from its frontal cerebral cortex into its most basic mode. You cannot fake that. You can't make that up. And unfortunately, not only can you not fake it and you can't make it up, but you have to sit here and watch yourself on video trying to explain this inexplicable and unexcusable accident. And you can't make sense of it because you know what? Most accidents don't make sense. As people, we like to ascribe intentionality to something. It makes us feel better, makes us feel safer. The truth is, accidents happen and we can't always explain them. And you can't certainly explain them well when you're experiencing that level of trauma. And that level of trauma associated most closely with unintentionality. By the way, I wish to say it again. That was elicited by the state from Dr. Rowe, not from the defense. That was their question and his response. Look at your notes. I don't know if I mentioned this before, but when you look at your notes from the morning of the cross-examination, you'll see Skylar, the memory on how he was holding the weapon came back to him in early 2015. That's what he said. They make a big deal of it, but Skylar, from October 17 until the week before last, wasn't allowed to talk at all. This was his first chance to talk since that event. Everyone can see the aftermath. We can't understand it. That's why we brought in an expert. We brought in an expert in Dr. Rowe, primarily to refute what the officers were talking about. That I didn't see tears. It didn't seem sincere to me. That's from Officer Moore, who gave us a very sincere demonstration of my client's hands and activities when he was handcuffed behind his back. But we got so much more. Because what we got is really an explanation of what happens during the 5.5-hour interview process, the interrogation. You see a kid who doesn't really know what happened. And they challenge him and he says, well, Maybe it didn't happen that way. I don't know what just happened. Thanks. And that's what's happening. He doesn't really know. And they say, well, the trajectory, funny that they would talk about trajectory when they deny trajectory in court. Doesn't line up with it, son. Doesn't line up with it. And remember, we have a kid who's deferential to authority. They say, you need to look at this for who he is. Well, you know what? We actually don't convict people for who they are. Okay? We don't do that. We look at the facts of what they've done, and if the facts support the law, then the jury comes back, and if it's beyond a reasonable doubt, they find a person guilty. That's what we do. And what happens is they challenge him, and he doesn't know. Remember, he doesn't know about this finger scraped, right? He doesn't know. And even Detective Jordan says, yeah, I threw the bone shard out there because if he didn't know what it was, he'd pick up on it. And he did. Of course, it's not a cut, it's a scrape. And the most logical explanation is that he didn't have a handle on the gun. And the ironic thing is that perhaps his first explanation of how he couldn't remember how it was may actually be closer to anything. Think about this. Skylar, I want your chair. Sorry, kid. I want you to ask yourself how you really think this happened, where she was really sitting. I think Kay Sweeney had it right. Here's the amazing thing. 6 million, I'm going to show a picture, you don't want to see it. 6 million points of data, 14.5 million pieces of data. They can measure everything to the millisecond, milliliter, the smallest little infinitesimal amount. Okay? Everything they can measure. But you know what they measure? They only measure the things that fit their theories. That's why we had an expert to measure to fit the facts. And the fact is, Brian Johnson said, well, you can't determine that without a terminal point. Brian Johnson, who, by the way, says, no, Dr. Clark did not say that you could pass a straight line all the way back to the gun. But Dr. Clark did say that. I brought him back here just to say that. Probably not 46.5 inches, but .47, pretty close. For this rough court demonstration, I'll be fine. 47. Okay. This may be loose now, but what was it before it got hit by a bullet? Before it got shot? I don't know. The height of this chair? I don't know the height of this chair either. But we do know the height of the chair. In this picture, from the full scene scan, we know the height of the chair, the back of the chair, the relative position, where she was sitting, where her feet were. We know that her feet didn't move because there's not blood on the feet. We know all these different things. That's why we had a forensic scientist come in and reconstruct it all. And when he looked at the chair, her feet, the fact that she had been swiveled, the chair had come back, but her feet did not touch. Remember, when she's sitting in the chair, all right, we've got Holthouse, Rodriguez, Unfred, Dan Brown. They all come in and they say that she is either sitting here or here. They move her back. Okay? All right? But her feet, wouldn't certainly go up, would they? No, they'd stay where they are. Because this part doesn't move. She's wedged in. And we know her body position because if she was reading and typing and moving forward, she'd continue to fall forward. Okay? If she, were leaning back, she'd continue to fall back. But none of those things happen. This chair is probably not any simile of the chair that she has. It could be stiffer, looser, whatever. What she does is she slumps because she's in a neutral body position. She's in a neutral body position. And Kay Sweeney says, we know from the body position where she was and how they found her and what the testimony was that she's in a neutral body position. We take her measurements, her height, the height of the chair, the back of the chair. We look at the fact that this entrance and exit wound is through and through. And they talk about, there's this deviation. No, there's not. It may look larger here because it's coming out here. This part here is a laceration. He calls it a laceration. And he measures her. And you know what? 46.5 inches. And 46.5 inches. Straight line through and through. And what does Brian Johnson say? Well, we couldn't determine anything unless we had a terminal point. Let me make sure I got this exact wording correct. I believe he called it a terminal point. Terminal point. I think I have it written 4 places. Terminal point. Can't figure it out because we don't have a terminal point. Really? That's your terminal point. And it's 46.5 inches. Now, Mr. Rosser says something about where 46.5 inches is to him. This is 46.5 inches. I'm not as tall as my client, but I have heels on. That's 46.5 inches. Why is 46.5 inches important? Because this is 46.5 inches. A kid admiring what he put together. By the way, I hope you heard the little gem of testimony that came in on, I think it was even on Cross, that said, you know what? We'd actually never fired that weapon before. She'd never taken it out before. And you saw from the video, that they don't have videos of that gun being fired. They have it from being held. The properties of that gun weren't really known. I mean, he had the gun, and he didn't build the gun. He customized it, put cool things on it, painted it, and all those other things. But he didn't take it out. There's no evidence of that was ever fired before. The evidence is to the contrary. I don't know. There was this evidence of slam fire. They talked about it. And the interesting thing was, on the evidence of slam fire, they actually brought a witness in who was shot by a slam fire. Johan Skuman, their forensic expert, in a slam fire with the gun, actually took shrapnel in his foot. He said this gun was in perfect working order. Well, that's probably true. Through, and he takes his 40, 50 years of experience and he applies it. Vincent came up with plus or minus 5%. Although clearly the study said an experienced examiner can do better than that. Then our experienced examiner did. Now, he has her upright in this position, neutral, at her height. If she's slumping and she's moving down at all, which he doesn't say that, but if she were, the gun would be lower. Any higher, she doesn't slump in that perfect position from a neutral stance. So we know where she is. We can figure all that out. And it is pretty amazing, by the way, to hear criticism from the Lakewood Police Department on forensics, when let's just start rattling off the stuff they never photographed and they never collected. They say there are bottles above the fridge. Okay, show me a photograph. One person said, yeah, I think it was a little bit left in some Jack Daniels. There are clothes on the bed. Collected? No. Did each thing get swabbed? No. Took a representative sample. Okay. Well, what about the gun? Did you look at the gun microscopically from head to toe? No, we just had him look at the muzzle part microscopically. And you know, you've got to wonder if they even could have looked at anything at all after they took it off the ground, off the sock that it was sitting on, laid it on its other side and photographed it. If the evidence had been preserved, we might have been able to see that piece of skin. But they handled it and fired it and did everything else they did to it, and they never microscopically looked at that. The one part they did microscopically examine, they actually did find something that looked important on it. The one part they looked on, right, before they test fired it 6 times and did all the other stuff with it and drop tested it and, you know, all the other stuff they did. And this, right here, you will be able to get as close, if not closer, than Brian Johnson, who, along with Sale, taped this so that we cannot look any closer at it than the photograph. But it's a shot, and unlike Brian Johnson, Kay Sweeney knows the composite materials of this, studied it, and looked at it, and he said it hit at a 90-degree angle. I tell you, today there is some play in that. I don't know what play was in it before. I know they found other pieces, or what it was even up against, I don't know. But that's a straight-on shot. And we know it's through and through. So we know that 46.5 is the right height. Okay. Shouldering a weapon, 55, 56 inches. A little bit more if you're taller. That's very much different than this. The state doesn't want to measure anything if it doesn't support their theory. If it helps their theory, they go no further. When Skylar says, you know, I had it up high, I had it on my shoulder, you shouldered it, son. Son, you shouldered it. And they stuck with that. But they could have had this poor young kid probably twisted up 15 different ways if they wanted to. They got to what they needed, what they thought showed what they believed, and they stopped. But they didn't stop to preserve the evidence or collect the evidence, or when they even went back in the light of day. Oh, by the way, remember too that they failed to secure the back door, and then I forget which officer testified. that they knew that there was a report of the door being ajar sometime between the first and the second time they went back in. But everything looked the same to them, and we didn't find anything else. Okay, well, maybe it was there, maybe it was removed. I don't know. I mean, that's what securing the scene is supposed to do, to make sure that when you go back to look for stuff, that it's all there. That's why you collect evidence like bed sheets, clothes. They did I hate to talk about intimate things. I have to. They collected a vaginal swab and they didn't find DNA. Did they swab her clothes? Her skin? They had sex, and by the way, they said, oh, there's no time for sex. Yes, there is. It's the first thing they did when they got home. He took his BDUs off and tossed everything outside, and he put his bathrobe on, and they went in the bedroom, and they cuddled and played around with each other, and then took a shower. And then the pizza was there, and she made phone calls, including probably when he was in the shower. And you know what? How could he possibly be cuddling with his wife while he's texting? These kids are 19 and 20 years old. How could I possibly text my wife while I'm in the middle of a jury trial? I can. Because you can lay right there with your phone and FaceTime and talk and text. All those things can happen. And in the hour or so where there doesn't appear to be much phone calling or texting going on, maybe 30 minutes, 45, you'll have all the evidence, piece it out. That's when they hooked up. That's when they got together and made love and then took showers. Skylar, even now, he can't figure out exactly what it was that he was doing. Because it's inexplicable. We know this. A person is criminally negligent or acts with criminal negligence when he or she fails to be aware of a substantial risk that a death may occur, and this failure constitutes a gross deviation from the standard of care that a reasonable person would exercise in the same situation. When criminal negligence as to a particular result or fact is required to establish an element of a crime, the element is also established if a person acts intentionally or recklessly as to that result. Criminal negligence, when he or she fails to be aware of a substantial risk that a death may occur. You don't look in the gun. You have failed to be aware of a substantial risk. You fail to be aware of where you have oriented this weapon. That is a gross deviation from the standard of care. The things that happened after that, and it was on cross-examination too, Mr. Greer said, that doesn't make sense. And he said, after my wife died, nothing made sense. After my wife died, nothing made sense. That's exactly right. because he's panicked and he's scared and he's freaked out and he's running around, and none of it makes sense. It doesn't make sense. And his statement doesn't make sense. But because you are in your criteria A trauma, you're white as a ghost, flight or fight response, and you are, according to Nina Bergmark, Ben Bergmark, Thera Dill, James Dill, the police officers who are there, babbling. Incoherent, repeating the same thing over and over and over again. It doesn't make sense, and you're not making sense. And he didn't. They want to take a kid who's panicked and freaked out and say, look, there's your premeditated murderer. When in fact the psychological evidence and the forensic evidence and the evidence from the witnesses suggest just the opposite. There's a kid who didn't plan anything out and didn't think ahead and didn't intend to kill his wife and absolutely broke apart when that happened. That's what happened there. That's what happened. Ben Bergmark. I think I said in my opening you were going to like him. Hope you like him. Because he's doing his best, and everyone who does their best deserves something from us. Ben Bergmark doesn't remember what he told the police. He says, that was me, I said that. Now, imagine for a minute you're a defense attorney and you have to cross-examine a witness about a statement they don't remember saying. Well, you can't. You're stuck. So you have to go through the little itty-bitty stuff to see what you can find. And we found it in the 911 call that we made sure you got to listen to. What did it say? So she shot herself. And then he says she shot herself, and she says she shot herself. He says, let me ask. And on the 911 tape, Ben Bergmark says, so she shot herself. He asked the question. And then he comes back and says, no, the victim, the husband doesn't want to talk about it right now. You're going to hear that. And I asked Ben Bergmark, if he said that, if you knew that, why would you ask that question? And he said, I would ask that question because I didn't know. Because I didn't know. Now think of what Ben Bergmark says. By the way, this is not as cool as PowerPoint, but it never runs out of batteries. It's always here for me. Ben Bergmark. Screaming from 301, high-pitched, overwhelmed with emotion, lost all color in his face, white, the t-shirt. Maybe, you know what? Lost all color in his face. I think he was wearing a white t-shirt, sorry. She's not breathing. You don't want to see her how she is. I love her. Got that it was an accident. Got that she was dead. Is she okay? No. I can't remember exact words. Uncontrollable sadness. Overcome with emotion. Going to kill himself. Told him to sit down. Went inside and out. Relayed the info to Nina. She's shot. She's dead. He kept saying that over and over again. Look at this. So she accidentally shot herself? Is that correct? Or what you've been told anyway? She accidentally shot herself? He asks. Okay, because he's asking someone. The victim of the husband does not want to talk about it. Okay, so we just need somebody here. Now, he didn't get close to my client after that. So if he didn't get close to my client after that, those things must have been said before that. Logic. And he would not have asked if that in fact would have been said. You will listen to what Ben has to say. In fact, you'll listen to it. You heard part of it, you'll hear the rest of it. And think about this. Think about what Ben says. I was knocking at the door, just saying, hello, hello, hello. Hey, can you hear me? Goes on. His face was like unnaturally white. It looked like he'd just seen a ghost or something, and it just looked like he was, it just happened. So like, hey, what's going on? And look at this. He says, and he said, my wife was cleaning the rifle, and I guess they went hunting, and she was just cleaning the rifle, and I guess they left around, and he just kept saying his wife's name over and over again. That's what's happening. He's saying his wife's name over and over again, and he's saying, she's shot, she's dead. Ben's trying to explain it, but even later on, you know, they say, okay, well, you're just assuming it's a hunting rifle? And he's like, yeah, I'm assuming it's a hunting rifle. Because he thinks they got back from hunting. No one ever said that. Do you think this kid, who you can hear in the background screaming, Danny, no! Oh my God, stomping around, says, by the way, we just got back from a hunting trip? It doesn't happen. That's Ben, in an also panicked, freaked out way, saying, I think this is what he's trying to say or what he's trying to tell me. Ben came and told you what he remembered. I cannot cross-examine Ben about something he doesn't remember. They got a chance to play it, but I would state that between an interpretive audio from Ben Bergmark, where he's trying to help the police explain what happened, versus his memory when he comes to court and he tells you his impressions, obviously there's an argument that they can make. I think it's clear. I think you can listen on the 911 tapes, and he never says this, she shot herself. And there's no evidence from any witness in this courtroom that came in and said, yeah, I heard that. They talk about these different versions, and there's really just a single version of a scared and panicked kid who can't figure out what happened, and he's been trying to figure it out. The evidence is important. The physical evidence is important. And also, the evidence that's not here is important. We heard a lot about gunpowder residue. Your Honor, this might be a good time for a stretch.
Right. Yeah, did you want to take an actual recess?
May I? Sure. Thank you.
Members of the jury, we're going to take a minimum 10-minute recess.
Right, when is it recess?
We'll be at recess for the next 10 minutes or so. You feel free to go back to your business. Captain, we have facilities back there too.
Hey, can we open it up there?
We have lots of water. Water back there.
Okay. Thank you.